Monty, do you want to start us off?
Sure. Dear Heavenly Father, Lord, we thank you for this day, and Lord, we just ask that you be with us today as we conduct the county's business, and that we do it in a manner that's acceptable to you. Be with all of our county workers that have been out all night and are out today, first responders, road department, all those that are out helping from last evening and today. And we just pray all these things in the name of your Son, Jesus Christ. Amen.
Amen. All right, we'll go ahead and call Marshall County Fiscal Court to order, November 12th, 2019. Erica couldn't make it in this morning, and Wendy, they were out all night with the road department, so she's not going to make it in today. I told her that we didn't really have anything on the agenda for her, so they're going to be out doing the roads all day. So first item on the agenda is Benita Walker. Good morning.
Morning.
Y'all are staying warm?
Good morning.
Hi, I'm Bonita Walker. Sure most of y'all know me. I've been having an ongoing issue for a few years now. It seems to be unable to be corrected by the local and state agencies that are tasked to correct this issue. I'm co-owner of a few farms that we have crops on most of the year, as well as trees that we've logged from time to time. We have fences for our critters, as well as residing on part of one of the farms. While I co-own 5 parcels of land, and we pay taxes on those farms like responsible landowners do, I'm only speaking of the farm off of Salem Chapel Road South, Green Acres Lane, Olive Hamlet Road, and Annie Creek area. I'm sure y'all are aware. While I've had these same issues on this property for over 13 years, it seems to be resolved for only a short period of time with the change in leadership at Marshall County Sheriff's Office and Marshall County 911. It has not lasted. I'm continuing to have ATV trespassers and no, or rather very delayed response from Marshall County Sheriff's Office. This last issue, it took 2 calls to Marshall County 911, 2 hours apart. One on October 19th, 2019 at 11:05 p.m. when the dispatcher told me that he would have a deputy right out. The second 2 hours later on 10/20/2019 at 1:08 a.m. when the dispatcher asked me if I still needed a deputy. Really? I responded that I needed one 2 hours ago and still needed one now. He stated that a deputy had called and left a message at the number that I called in on. That's just not possible. I do not have voicemail set up on my iPhone at that number, so I'm not sure who the deputy called. Marshall County Deputy 54 did finally arrive at 1:14:33 a.m. There were no ATVs on my property at that time, though they still could be heard from my farm. The deputy did explain that there were 3 emergency calls that dropped within 3 minutes of my call. I feel that tearing up my newly planted, and I called it drilled when I called in to 911, my newly drilled wheat, which is my income source, is an emergency. One of them, I found out, was a 1045, I believe it was a 1045, which is a non-injury accident in the city of Benton. The second was a stolen ATV, and the third was a domestic. I have 0 issue with being placed behind the domestic. None, 0. And I stand firmly behind both of the deputies that were on duty, going both to ensure their safety and to handle the domestic. I wonder why, though, I was placed behind a city 1045 and a stolen ATV, even when the dispatcher from the traffic, I do have a copy of it, questioned the deputies if the ATV in question could be what they were looking for. My major issue has been the lack of contact by either Marshall County 911, who has called me back before to say that the deputy was not coming and to remind me that I couldn't do anything anyway because I was on probation. Though what that had to do with anything and why they said that was truly frustrating and really made me angry. Or by the deputy who claimed to have left a message, but I had 0 missed calls and he or anyone could not have left a message. I will give kudos to Chris Freeman, Marshall County 911 Director, who has stepped up and admitted that they have messed up and has stated that it will not happen again. I did talk to Sheriff McGuire, and I suppose that he felt like that I was joking as he made what I'm guessing was a joke and said, maybe we'll get there in time next time. I have 0 sense of humor about this. The sheriff has made 1 call to my farm before over trespassers. It was on a Tater Day when Marshall County 911 told me that no one was available to take care of the 5 full-size vehicles with 11 people ages 6 to 23 that had decided to drive through my farm and gotten stuck, with one being a pickup truck with a bunch of booze in the back. I told those trespassers, okay, as well as telling 911, okay, gathered the driver's licenses of all 10 of those that had driver's license, the 11th being a 3-year-old, and escorted them off my property to Green Acres Lane. Imagine my surprise when not 1 but 2 deputies pulled up to that property and promptly told me that I had no right to escort those trespassers off of my property. None of the trespassers were cited and arrested, and I found out later that 7 of the 10 trespassers were emergency responders' children. One of the deputies even insisted that I had no right to let them back on my property to get their vehicles, and that I could not have those vehicles towed. You recall that, Sheriff? Okay. So when is Marshall County Sheriff's Office going to put a stop to the trespassing on not just my farm, but all of them? It's no different to me for those ATVs to ride across the farms than it is for them to ride through Shopperama, Walmart, the resorts, Dollar General, the U-Pick farms, and even on the roadways. There are three instances that ATVs are allowed on the roadways in the Commonwealth. That's surveyors, construction workers, and farmers, and that's per KRS. That's the Kentucky Revised Statutes. And Marshall County 911 has to take these calls seriously. This is folks' incomes, not just mine. These riders destroy crops, lands, fences, and animals, because if they tear the fences down, the animals gets out. And that can destroy lives. After that, the county attorney, bet you thought I was going to leave you out of this, didn't you, Jason?
No.
And the judges have to do more than slap their wrists. They have to take those rides. They have to take the ATVs and their licenses. They have to make them pay restitutions and make them work on the farms that they destroy. In addition to the fines and community service, you guys have let this go on too long. Some of us have a spine. Apparently it's me. We've had enough. Any questions?
Benita, what are you wanting from the fiscal court?
I want you guys to ride these people.
I'm sorry?
I want you guys to ride these people. I'm wanting something done. You know the background of this.
I do. I know you and I have talked and last year, and as a property owner myself, I share some of your concerns. But as far as the fiscal court, because we have no judicial powers.
I understand that.
Tell me,
Is there anything that can be done, anything at all? Can we make this any kind of priority?
I mean, with the fiscal court in regards to ATVs, there are some counties that have ordinances that may help beyond the state statutes. I think that there's been several times you've had ATVs. I know when we talked last year, you had how many? 200? Is that about right?
In the 11-year period prior to my arrest, there had been over 200 calls to Marshall County Dispatch in that 11-year period. But then we have a new administration here. He's done great until this last time.
Well, I mean, as far as actual trespassing. You've had several.
I've had over
To say
200
it,
trespassers.
yeah.
It has slowed down a lot, but they know I can't do anything now. They know I can do nothing.
Well, do you have, is it my knowledge that you have photos of folks that are trespassing on your property?
we had moved the cameras this time because it had been such a extended period of time. We moved the cameras. The people that had trespassed this time actually posted pictures, and I sent these pictures to Marshall County 54, but I no longer have access to those pictures. I'm now blocked. I'm not sure how they found out that I sent the pictures to him, but I did email pictures to Marshall County 54.
I guess if a landowner has and photos of folks on their property trespassing, is that something that can be worked as far as identifying those individuals and summons to court for? Because I do agree that in a case like this, I also understand the sheriff's department. I mean, their resources are some cases limited. They respond by the priority of the calls.
I get that.
But if you've got photos of folks that are trespassing on your property, I would think that can be, if they can identify those individuals, that can be investigated and brought in front of the judicial judges, who then, in my opinion, should make an example so that future trespassers don't get themselves in a compromising situation.
I actually have a case working right now with trespassers, and it's actually drug on for a little over a year now.
Yeah, but I mean, it's not the fault of anybody's, because there's a witness who's in jail. So, I mean, there's nothing that we can do.
I understand
Who's in
that.
jail, so.
But it's, it's very time consuming, it's very frustrating, and it continues.
And I'm a landowner too, and I'd be frustrated as well. I know we talked last year. I think there's more. Obviously, I'm not involved directly, so there's more to it. From the sheriff's department to the county attorney's office and to the landowner, each incident is obviously unique to itself. But overall, it seems to be an issue with folks in this county that don't appreciate private property, and landowners, they do have rights, and it's a fine line, I guess, in an investigation standpoint, where obviously the sheriff's department can't be everywhere in the county. This is a fairly large county, but if there are resources that the landowner can do or take and use to get photos of those that trespass, then that to me seems like one of the best ways to get them into the court so that they can be held accountable.
Agree, but it begins at Marshall County Dispatch. If dispatch will not send the deputy, will not prioritize and send the deputies out, and
Well, let me, and that's a great point. The dispatch, and I saw Chris, he's here, correct me if I'm wrong, but in my experience, dispatch receives that emergency call. Depending on what agency is to be notified, dispatch then notifies that agency.
correct.
The individual agencies have their protocols as far as priorities and how they're going to respond. And I believe in this case, the deputy was responding but then pulled off because of an accident.
That's correct. There was three calls that dropped immediately within 3 minutes after the time I called.
Yeah.
I have the CAD sheets.
Yeah. So, I mean, for somebody who's managing their personnel and prioritizing those calls, I understand that. They have to make those decisions. In some cases, in a split decision, it can be at a time of night or day when it is extremely busy. But overall, especially with you and I have talked about this, your property is unique because there's a lot of trespassing apparently on your properties. And I agree that if we can identify some of these folks, I agree with you. These folks need to be brought in, identified, and stand in front of a judge to be held accountable. But each situation, I can't sit here today, and
That's right.
I'm not involved in it, but it is sometimes difficult to get an end result. As far as the fiscal court, we do ordinances. There are counties that have ordinances. But an ordinance is just another document. You got state statutes that are apparently being violated, so,
It's a piece of paper, just like a domestic violence order.
right. But, I don't know if Eddie, you got anything you want to?
We don't mind putting pictures on Facebook for folks to identify.
Well, the last time I done that, I was smacked, so to speak, not literally, but figuratively, by the former sheriff. I'm sure you wouldn't do that, but.
No, I wouldn't smack you, no.
But I got in trouble the last time I done that, when I posted pictures of
No, well,
some
we'll
trespassers.
post them on our page.
Well, I
You
have,
got-
I have
you got
zero
pictures,
issue posting
yeah.
them on my page either, and making them public for everybody to see. But I
No.
got in trouble because
Somebody will know who they are if they're Olive,
Yeah.
Fairfield.
well, the last time they were personal friends of the former sheriff, and one of them happened to be a registered nurse.
I can't do anything. I can't change that.
No,
Well,
I
and
understand that.
what-
But things have gotten better with the new, and I even said that more than once.
I agree.
Well, in the,
We just have to prioritize, and I believe we were in pursuit of that stolen.
You were, I
I think it's
mentioned
not
that.
just
That's
a
one of
stolen
my-
report. I think we're actually in pursuit of that vehicle, and then as far as, 1046 in Benton, I think they just helped on an injury accident.
Was it a 46, not a 45?
I thought it was a 46.
All right. Was it a 46? I apologize, I was wrong.
46 is an
I have no
injury,
issues-
45 is
I have no
wrong.
issues admitting I'm wrong.
But that-
well, I think we all understand that your property gets a lot of trespassers.
It does.
And, the fiscal court, we're discussing it today, but, we don't have any judicial powers in this governing body, but, I think that the agencies that are there, if you find photos of folks on your property, that to me would be the best way,
It's
to
not
seek
just my property,
prosecution.
but the other farmers that I've talked to have said, I'm just tired of it, and they're
Mhm.
not gonna do anything. And I said, well, I'm not afraid of them. I've grown accustomed to this, and I have no fear. I don't care to go and speak, but I'm only gonna speak for me.
Sure.
Even the people that farm my property said, it's fall, we're gonna have trespassers, they're gonna tear up our property. I said, why do y'all put up with this? And it's just a way of life. It shouldn't be a way of life. They shouldn't tear up our property, they shouldn't tear up our crops, and like I said, it's no different than driving through Shopperama, driving through a U-Pick farm. If I'm gonna use Chris for an example, if Chris had a U-Pick farm and they drove through it, he would be livid.
Sure.
If they drove through your farm and tore your fences down and your cattle got out and a car hit one of your cattle, you would be responsible.
Mm-hmm.
So, and that's just the way it is. Not only would it destroy your cow or your bull,
Well, and I don't think we should leave it up to the landowner to take matters in their own hands, because you're a prime example of
prime
that.
example here.
And I do know the last administration was not going to enforce anything. That's not good governance for the landowners. I think it was said best, there are statutes that, specifically state that you cannot, say, take matters in your own hands, using deadly force on a criminal trespassing situation. But it doesn't mean that a landowner won't. And that's what people need to understand. So for me, if there's anything that we can do, is to make sure that landowners are not taking these matters in their own hands, because typically the end result's bad for the landowner.
That's why I wanted to bring it to public attention.
Mhm.
And maybe if it has a little bit of public attention,
It'll help.
maybe some more people will step up and say, I'm having this issue too.
Yeah.
And maybe if more people step up and say, I'm having this issue too, perhaps sheriff can get some more funds, maybe have a deputy strictly for ATV traffic where it's needed. That's a big maybe, that's a big if, but perhaps something can come of this. But I'm not the only landowner that's having this issue.
Sure.
The nature of this offense, as you know, is to prosecute it, it's basically either caught in the act or video or photograph evidence of who's doing it. So that's what makes it hard to enforce. You can have all the laws on the books that you want to, but when it comes to actually pinning somebody down in a criminal case, the proof's got to be there.
I've gave you over 15 CDs of somebody in the act.
And we've got him charged.
I understand that. And it's still a time-consuming process.
So you actually have actually turned over evidence to where you actually prosecuted somebody?
Yeah,
And
this
that-
is not an ATV issue, it's a
not an
neighborhood.
But it's
ATV
something
issue,
else.
But it's a
Okay.
trespassing issue
But yeah, we've
Gotcha.
got him charged.
and violating a court order.
Yeah,
Yes.
okay. No, I understand. I feel for the agencies too, because I know
It's
it's,
not his fault. It's not his fault. It's not Chris's fault.
right,
It's a conglomeration of the feces impacting the impeller.
yeah.
Snafu. I know you know what that means. So, there we go. And by the way, happy Veterans Day to all veterans. Thank you for your time.
Thanks, Benita.
Thank you.
Under correspondence, let's see. I see Brian's here. Good morning, sir. This is the recommended order of the General Obligation Bond Series 2019. I see you made it. You didn't end up in the ditch.
I made it. Took a little longer than normal, but we're here. Not too bad. Yeah, basically, the letter there is just from the hearing officer at DLG, State Local Debt Officer, basically approving the bond issue. So the next steps now are getting the rating, which we got your bond rating yesterday. They maintained it of A1, which is fantastic.
Great.
That's what we were hoping for, expecting, especially when you're adding debt, that they maintain the rating. So in that letter, like I said, the next step after getting the rating, which we've received, is we have to wait until they allow what their period to accept exceptions for this are. Someone could come in and contest that this bond issue is legal and you've done everything correctly. So in there it says, written exceptions must be received by the close of business on Monday, November 18th. So on the 19th, I'll write to the hearing officer, assuming there's no written exceptions. At the debt hearing, no one was present, so no one was there to object to it. So in theory, there's no way they could write an exception if they didn't attend the hearing. And then we will sell the bonds the next day on the 20th. So we expect to have your offering documents, the rating report out to the market this afternoon or tomorrow for potential underwriters to look at. And then we do the actual bond sale next Wednesday. Go ahead and set that interest rate.
Okay. Perfect.
Sure thing. And then funds will be ready, I believe December 11th is what we're targeting to start paying the bills.
Okay.
And you said on the 20th, we'll know the rate?
Yeah,
Is that what you said?
20th, I believe we got it set for 11 o'clock Eastern, the bond sale. So we'll know then. I'll give the judge a call, let him know hopefully the good news. Hopefully nothing crazy in the market happens. Rates have remained pretty low. They've gone up and down. You saw the Fed lowered rates. They went down. They kind of popped back up just a little, but still below where we were initially talking by a great deal.
Sounds good. Does anybody got any questions?
No, we appreciate you driving. all
Yeah.
the way down here
Sure
for
thing.
that,
I'm
though.
about to head to Carter County for an evening.
Oh,
meeting,
okay,
so
good.
I've got a day.
So
Good.
you got a day of driving?
Good.
Okay. We may have to, in the future, on inclement weather days, try to do a teleconference or.
I could have been smart and came here last night, but I don't claim to be too smart.
Last night have probably been worse.
Yeah.
It might have, yeah.
Yeah.
I came in this way first, didn't it, before I got to northern Kentucky.
Yeah.
So. It was a pretty drive most of the way. I can say that.
Well, Brian, I appreciate it.
Sure thing.
Thank you,
Appreciate
sir.
it. We'll let you know. Be talking soon. And
Okay.
congratulations on the rating. And good luck
Great.
next Wednesday. And we'll
Okay.
be working.
All right. Thank you.
Thank
Thanks,
you.
Brian.
Old business, approved the minutes, October 16th meeting and the October 29th special call meeting.
Motion approved minutes.
Second. All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Ordinance 2019-12, electric meter fee for 911, second reading.
All right, this will be the second reading of ordinance number 29-12. We did a full reading last time, so I'm just going to do a summary this time.
Yeah, his mouse pad there, that thing is crazy.
Is this Apple?
Yes.
Yeah. Other way.
Let's not get in trouble with Apple, please.
All right. So I can just do a button. All right, okay. Okay, so this is titled an ordinance establishing and imposing a fee on electric meter bills to facilitate funding for Marshall County 911 and permitting electrical providers a mechanism to receive reasonable compensation for their efforts in collecting the fees. Scrolling down here. Section 1 imposes the $7 per month on an active residential and commercial electric meter. An active electric meter is defined as any electric meter that is producing revenue. Section 2 requires the providers to collect that fee and remit the amounts to the Marshall County Treasurer. The Treasurer shall use those fees collected for, keep those separate and apart, may only be used for purposes as permitted by state law. Section 3 deals with the retainage, that the electricity provider shall be permitted to retain 3% of withholdings from the administration of the fee. Electric provider may petition the Marshall County Fiscal Court to request additional compensation if it does not fully compensate the provider, if the 3% does not fully compensate the provider. And for purposes of this ordinance, withholdings means those fee monies collected by an electricity provider on active electric meters pursuant to Section 1 of this ordinance. Section 4 deals with the exceptions for double fees. An example of a double fee could be a case where a single-family residence that houses a single unit of residence has, for whatever reason, 2 or more electric bills meters servicing that one residence, and the goal is for one business or one home to have only one fee. So if there's a fee at a barn or a fee or a meter at a barn, within so many feet of a house, that would not be a double, that would be an improper double fee. So we just want one fee per month. Section 5, the Marshall County Fiscal Court shall review the fee annually to make sure that it's covering operating costs without unduly burdening Marshall County citizens. And then upon passage of this ordinance, the prior ordinance that we read earlier this year is hereby repealed, and that when fees are actually being collected to this ordinance, the ordinance on the landline fee is suspended. So that's the second reading.
Is there any questions regarding the second reading? If not, we would need a motion to approve the ordinance 2019-12.
So moved.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed?
No.
Motion carries. Under new business, item A, 2019 Peel and Holland Wellness Score Service Agreement. Should have seen a copy of that. We just need an action to approve it if there's no discussion.
Move we approve.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Bid proposal for Sid Darnell Road. Brad, you want to?
Yeah. Let's see here. So this was ran in the Tribune-Courier on a date. Yeah, no, the date's wrong. Not in here somewhere. It's okay. It's okay. I'll just read it. Marshall County Fiscal Court will be accepting sealed bids on a 24-foot wide by 70-foot long concrete box beam bridge for Sid Darnell Road. All the bidders must be on the KYTC pre-qualified bidder list. The specifications can be obtained at the Marshall County Road Department, 160 Homer Lucas Lane, Benton, Kentucky, between 7 a.m. and 3:30 p.m. Monday through Friday. All sealed bids must be submitted to the Judge Executive's office by 3:00 p.m. on November 7th, 2019. Questions regarding the bid should be emailed to wendy.greer@marshallcountyky.gov. The Marshall County Fiscal Court reserves the right to reject any and all bids. So we did receive one within the proper time frame, and it was from Smith Construction in the amount of $331,985. And this price includes all labor, materials, and equipment necessary to construct a new 24-foot wide by 70-foot long PC box bridge as detailed in the attached bridge proposal, and also the bid bond is attached. So Wendy and I went through this, reviewed it on Friday. It met all the specifications and the bid requirements.
Motion to accept the bid.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Item C, Merco's change order and invoices. This is on the sanitation, I believe. This is for the casing, for the sewer. This will get submitted to KIA for review. Actually, no, I stand corrected. That's not for the casing. That's the drawdown, I'm sorry.
Which one are you, on the change order?
Yeah. The November 6th,
Okay.
2019.
Move we approve.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. And then item D, Rivercrest draw request and invoice. Any questions on the Rivercrest draw and invoice? Good morning, Chad. I didn't even see you sitting there.
That's fine. Y'all can handle it
Snuck-
without me. You don't
You
necessarily
snuck
have to
in
have
on
me.
us. Go ahead.
No, I just want to be here to answer any questions on there. Unique on this draw request, there's actually two invoices from Mertco on there. One of them is their final pay request for the completion of the J line, what we call it, going up to the trailer park, completing that work. And then the other one is the release of retainage on that project. And we have recommended the payment on the release of the retainage on that project. That does not dissolve them from any type of warranties or anything like that on the work. What that does, that just allows them to gain that 5% retainage. Now that the scope of work has been completed on the project, we feel comfortable going ahead and recommend the release of that retainage. We have, if you do look through the budgets and the numbers, there's approximately $2,000 that has not been invoiced by Mertco for a demobilization cost, and that is due to the request that we submitted to KIA for the use of some of those residual funds. So rather than closing out the contract completely, we went ahead and talked with Mertco, and they agreed to go ahead and leave a little bit of money on the table so that we wouldn't call this the final pay request, and that makes things flow a little smoother with the funding agency.
Move we approve the draw request.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Do you have an idea, Chad, of a timeline with the KIA response on that?
I'm going to have to call them. I actually attended the KIA board meeting last week, and I expected it to be on their agenda, and it was not. So
Okay.
I did not have an opportunity to ask them after the meeting why it wasn't on the agenda, but they do have all the paperwork. They've acknowledged they've got the paperwork. We just need to get their response
Okay.
on that. But I will call them and I'll get back in touch with you.
Okay.
and let you know before the
Yeah,
next
let me
meeting.
know.
Will do.
Okay. All right.
Any other questions? If any property owners do say anything, we will work with them, and Merco will most likely be back again in the springtime once weather starts to turn again and we get some germination on some seed, and they'll probably have a little bit of settlement stuff to address, but that is under their warranty period, which will carry on from a year from September. So they'll have some time to address some settlement there.
Okay.
All right.
All right.
Thank you.
Appreciate it. Thank you.
Thanks, Chad.
Item E, payment of the bills.
Motion to pay the bills.
There's a second.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Item F, we need to go into executive session for litigation and personnel. Motion to go in executive session.
So moved.
Second.
All those in favor say aye. Any opposed? Motion carries. All right. Call court back to order. There's no further discussion. Is there a motion to adjourn?
So move. Second.
All those in favor say aye. Aye. Any opposed? Motion carries.